What is going on, Ape Nation? Ken Griffin is back at it again, and because Ken Griffin is back at it again, so am I. I'm on here making another video because, you know what, we have to address what Ken Griffin is doing, and we are going to get right into this video, but before we do, please go ahead and smash that like button, because it really pisses Ken Griffin off, because then this video gets shared with even more apes just like you. And for the love of God, if you're not subscribed yet, what in the hell are you waiting for? I drop content just like this every single day. But now let's get right into the video. So I'm not sure which country you're watching this video from. I'm not sure which country you're a citizen of, but in the country that I'm from, which is the United States of America, you have certain rights, and it would appear that Ken Griffin is trying to take some of those rights away. Some of those rights away from me, you, and everybody else, because when he attacks one of us, he's attacking all of us. And one person is doing something about it. One person is fighting for their rights. Excuse me, I take those words back. Not person, but ape. One ape is fighting for his rights, and we all should be doing the same exact dadgum thing. So let me briefly explain to you what's going on. There's a domain name in question right now. It is citadelair.com, registered at godaddy.com. And Ken Griffin has a problem with his domain name. But why? Well, Ken Griffin has a problem with his domain name because the guy that runs this domain, the website that's on this domain name, he's basically putting Ken Griffin on blast and creating memes and things of that nature. And that really gets under Ken Griffin's skin. Now, this isn't the only website out there that uses or that exposes Ken Griffin for the snake that he is. But this is one that just happens to use the name Citadel within the domain. So Ken Griffin thinks that he can pretty much silence this guy. He also thought that he could silence him on Twitter. Actually, he did finally succeed after a few attempts to silence this guy on Twitter temporarily by winning a case, or an arbitrage case, in a federal court. But the good people at Citadel Air, they're not going down without a fight, so they fought back by filing a lawsuit against Citadel. I've got the motion right in front of me. We're going to actually go over it on this channel today. Let me know what you guys think in the comments below, but I really love seeing things like this because this is the apes fighting back against an evil. A great evil known as Citadel, a great evil that is run by none other than Ken Griffin. United States District Court for the District of Arizona. Plaintiff being Christopher Britt Privily, LLC. And, of course, the defendant is Citadel, LLC, and its related entity, CETM Holdings, LLC. Nature of the action. Number 1. This action seeks declaratory relief pursuant to 15 U.S.C. 11142 DV to establish that plaintiff Christopher Britt Privily LLC's, together Britt or plaintiff, registration and use of the domain name citadelair.com, hereinafter the disputed domain, is not unlawful under the Anti-Cyber-Squatting Consumer Protection Act, ACPA, and its use of Citadel Air is non-infringing. So those are the parties. 2. Plaintiff Britt is a U.S. citizen with an address at 15 Great Came, Plymouth, Massachusetts 02360. 3. Upon information and belief, defendant Citadel LLC and its related entity CETM Holdings LLC, together Citadel or defendant, is a Delaware limited liability company with an address at 131 South Dearborn Street, Chicago, Illinois, 6063. Jurisdiction and venue. Number 4, this court has subject matter jurisdiction over this action pursuant to 28 U.S.C. 1331, 15 U.S.C. 11142 DV, and 28 U.S.C. 2201. That plaintiff's acquisition and use of the disputed domain is not unlawful under the Anti-Cyber-Squatting Consumer Protection Act, 15 U.S.C. 115D. This court has personal jurisdiction over defendant as a result of defendant's initiation of an administrative proceeding against the disputed domain pursuant to the Uniform Domain Name Resolution Policy. 6. Venue is proper in this district under 28 U.S.C. 1391 B2. A substantial part of the property that is subject of this action is situated in this district. Moreover, venue is proper in this district due to defendant's voluntary submission to this court's jurisdiction when defendant filed a complaint with the National Arbitration Forum concerning plaintiff's registration of the disputed domain. 7. The disputed domain has its situs in this district within the meaning of 15 U.S.C. 1125 D2C. The registrar for the disputed domain is GoDaddy, which is not only headquartered in this district, but upon information and belief, also has additional business locations in this district. 8. Defendant Citadel is an American multinational hedge fund and financial services company. It is one of the largest hedge funds in the world, and its billionaire founder, CEO Ken Griffin, has been listed as the 45th richest person in the U.S. Number 9. Plaintiff Britt closely follows the finance sector and has been an active member of various investment communities and finance forums on Twitter and other online platforms for years. In early 2021, Citadel received public scrutiny and extensive media exposure over its involvement in the GameStop trading controversy. Britt was and still is engaged by the social injustice taking place in the retail trading environment. It was at that point that Britt realized he wanted to create a meme or parody outlet to ridicule Citadel and its billionaire CEO while simultaneously exposing truths or facts in the GameStop scandal, as well as other newsworthy matters in the financial industry. 10. Prior to registering the CitadelAir.com domain name on May 14, 2021, Britt created a parody account on Twitter under the handle @CitadelAir. The Twitter account posts from the perspective of Citadel's CEO Ken Griffin's personal pilot, hence the choice of the wording Citadel plus Air. The parody perspective is reinforced by the profile description at the top of the Twitter page, which reads, Citadel Air helps meet the luxury travel needs of asset managers, banks, broker-dealers, hedge funds, government agencies, but we mostly just fly Kenny, with images of luxury private airplanes bearing complaints logo as shown here. As you can see right here, there is an image of this. Number 11, the same imagery and references to piloting or various flight services, flight history, and live flight tracking appear on the website at the domain name as shown here. As you can see, there's another image. Number 12, Britt took his first flying lesson in grade school and has a pilot's license. Number 13, Britt's Twitter account quickly gained a following. In less than 6 months, the account amassed over 5,000 followers. The Citadel Air Twitter account links directly to the disputed CitadelAir.com domain name, which, as noted, was only recently registered in May 2021. Citadel has attempted to have Twitter take down the Citadel Air account twice in a relatively short period of time, and both times Twitter reinstated the account within 24 hours. Paragraph 14. After exhausting its options with Twitter takedown policy, Citadel filed the underlying UDRP complaint in a further effort to silence Britt's speech. This is simply a case of a multi-billion-dollar company trying to silence a private citizen who is critical of its operations and pokes fun at its CEO's extravagant lifestyle. Paragraph 15. Britt chose the domain name CitadelAir.com because it playfully references the target of its parody, Citadel, and incorporates the word air in a humorous manner to ridicule the excesses of billionaire CEOs in corporate America, specifically Citadel's CEO Ken Griffin. As shown in the above images, Britt does not in any way suggest a direct connection with Citadel or any sponsorship or affiliation. Paragraph 16. Importantly, the disputed domain was acquired less than 6 months before the underlying UDRP complaint was filed, and Britt's website is not yet fully developed. However, it has placeholder information and links directly to Britt's Twitter account, currently the primary outlet for Britt's criticism. It is obvious that Britt's Citadel Air Twitter account is a parody, as it consists of a stream of memes and jokes with information to help followers better understand what Britt believes to be truth, facts, rather than reliable information from questionable sources or fake news. Paragraph 17. There has never been an instance in which a user or consumer confused Brit's use of Citadel Air with Citadel, or believed that Brit was actually operating an airline, and that Brit's memes were actually posted by the pilot of Citadel's CEO, Ken Griffin. 18. Citadel has not provided any evidence supporting consumer confusion, and none exists. Its position is merely based on unsupported assertions by its counsel. Paragraph 19. Conversely, Brit's intent to use the disputed domain in a parody is supported by actual evidence in the form of a popular Twitter account with funny memes and tweets. And to be clear, Brit has not received nor sought any commercial gain from his use and registration of the disputed domain. Paragraph 20. Brit is merely using the disputed domain for genuine criticism and to parody Citadel, its billionaire CEO in corporate America. Paragraph 21. Brit's inclusion of the arbitrary modifier air creates a domain name that is legally different from the Citadel trademark, parodies the Citadel name and services, and is being used for legitimate non-commercial criticism in a fair use manner. Paragraph 22. A quick perusal of Brit's CitadelAir.com website and related social media account confirms as much. It is clear, based on the context of Brit's use, that this is a parody and or legitimate non-commercial criticism. Paragraph 23. On October 18, 2021, Citadel submitted a complaint with the forum, initiated an administrative proceeding against Brit's registration of the disputed domain, and sought an order to transfer the ownership rights of the disputed domain to Citadel in violation of Brit's First Amendment and free speech right to ridicule and criticize defendant's Citadel trademark. Paragraph 24. The UDRP proceeding, Citadel LLC and its related entity CETM Holdings LLC versus Christopher Brit Privily LLC, claim number FA2110001968516. The proceeding was decided by a 3-member forum panel on November 29, 2021. A majority of the panel issued a decision directing transfer of the disputed domain to Citadel. Paragraph 25. The presiding panelist in the proceeding was a European citizen and attorney who failed to acknowledge and address the unique issues presented in the proceeding, which involved First Amendment and free speech rights under the U.S. Constitution. Paragraph 26. The respondent in the proceeding has 10 business days to commence an action in the district to stop the transfer of the disputed domain from taking place. Paragraph 27. Despite the fact that Citadel had agreed to submit to the jurisdiction of the courts of this district to decide de novo whether Brit's acquisition of the disputed domain violates Citadel's rights under the Lanham Act 15 U.S.C. 1125D, and whether Brit has a right to criticize and ridicule Citadel and its CEO, the panel did not apply U.S. law in reaching its decision. Paragraph 28. In filing the proceeding, Citadel chose to submit to the jurisdiction of this court and to have the laws of the United States as interpreted and applied by the Ninth Circuit and the courts in this district apply to the parties' dispute. Paragraph 29. Yet Citadel completely disregarded the laws of this circuit in filing the proceeding. Paragraph 30. The panel in the proceeding wrongly determined that Brit's Twitter account was irrelevant to the cyber squatting claim. Despite reaching that erroneous conclusion on information and belief, Citadel has now taken the decision in the proceeding to Twitter as grounds to suspend Brit's Citadel Air Twitter account. Paragraph 31. On December 8, 2021, Brit's @Citadel Air Twitter account was suspended. Paragraph 32. On information and belief, Brit's Twitter account was suspended due to Citadel's takedown request based on a wrongly decided UDRP decision that involved legal issues unique to U.S. law that were ignored by a foreign attorney serving as the presiding panelist. Paragraph 33. Under U.S. law, a claim for cyber squatting cannot stand if the domain name was registered and used for protected free speech purposes. Furthermore, the trademark holder must establish that the domain name was registered with a bad faith intent to profit from a known trademark. Paragraph 34. The plaintiff here registered and used the disputed domain in parody and criticized the defendant, which is his right under the First Amendment. There is no bad faith intent to profit in this case, and the defendant will not be able to prove otherwise. Paragraph 35. Upon information and belief, defendant was aware that its UDRP complaint needed to meet the standards, not of the UDRP, but of the Lanham Act and the U.S. Constitution. It was not enough to craft a complaint that could prevail in an administrative dispute proceeding that may be decided by panelists outside of the United States who may not understand or be qualified to interpret U.S. law. Paragraph 36. At no point did plaintiff offer the disputed domain for sale. Paragraph 37. At no point has plaintiff offered any domain name for sale. Paragraph 38. The underlying UDRP action was filed to silence a dissenting voice in an obvious parody. Citadel had no basis to support the UDRP proceeding. Paragraph 39. On information and belief, Citadel has now used the UDRP proceeding to further silence BRIT by having the Citadel Air Twitter account suspended. Paragraph 40. For the above reasons, plaintiff seeks a declaration of the disputed domain is rightfully owned by plaintiff and that plaintiff's use of Citadel Air does not infringe or dilute any claimed trademark rights that defendant may claim in any Citadel trademark for its financial services or any goods or services. Paragraph 41. In accordance with the Internet Corporation for Assigned Names and Numbers policy, plaintiff provided notice to defendant that a lawsuit would be commenced against it concerning the disputed domain name within a 10-day period. Count 1. Declaration under Anti-Cyber Squatting Consumer Protection Act. Paragraph 42. Plaintiff realleges and incorporates paragraphs 1 through 41 above. Paragraph 43. As stated above, plaintiff registered and used the disputed domain to parody and criticize defendant and its billionaire CEO. Paragraph 44. As such, plaintiff's registration of the disputed domain violates no right of defendants under the Anti-Cyber Squatting Consumer Protection Act, 15 U.S.C. 1125D. Paragraph 45. In registering the disputed domain, plaintiff did not have a bad faith intent as provided in 15 U.S.C. 1125D1AI to profit from any mark owned by defendant. Plaintiff's intent was to parody and criticize defendant and its CEO, which is clearly evident in plaintiff's Twitter account of the same name. Paragraph 46. In registering the disputed domain, plaintiff did not have the intent, as provided in 15 U.S.C. 1125D1B, to divert consumers from defendant's online location to a site accessible under the disputer domain that could harm the goodwill represented by the mark, either for commercial gain or with the intent to tarnish or disparage the mark by creating a likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of the site. It is obvious that the disputed domain is a parody. Plaintiff does not offer actual flight services, nor does the defendant. As such, there is not even a potential for any likelihood of consumer confusion. Paragraph 47. In registering the disputed domain, and at no time since registration, has plaintiff offered to transfer, sell, or otherwise assign CitadelAir.com to defendant or any third party for financial gain without having used or having an intent to use the disputed domain in the bona fide offering of any goods or services, nor is there prior conduct by plaintiff indicating a pattern of such conduct. Paragraph 48. Plaintiff has not registered or acquired multiple domain names that he knows are identical or confusingly similar to marks of others that are distinctive at the time of registration of such domain names, or dilutive of famous marks of others that are famous at the time of registration of such domain names, without regard to the goods or services of the parties. Paragraph 49. Plaintiff has not registered, trafficked in, or used a domain name that at the time the disputed domain was registered in 2021 was identical or confusingly similar to any mark alleged to be owned by defendant. Paragraph 50. Plaintiff believed and had reasonable grounds to believe that his registration of the disputed domain was lawful. Paragraph 51. As required by 15 U.S.C. 11142D, plaintiff has given notice to defendant of his intent to file an action to establish that plaintiff's acquisition and use of the disputed domain is not unlawful under the ACPA. Count 2. Declaratory judgment. Paragraph 52. Plaintiff realleges and incorporates paragraphs 1 through 51 above. Paragraph 53. A dispute exists between plaintiff and defendant concerning plaintiff's right to acquire and use the disputed domain and plaintiff's right to use the wording Citadel Air to parody and criticize the defendant in a non-infringing manner. As a consequence of the dispute, an actual and justiciable controversy exists between plaintiff and defendant. Paragraph 54. Plaintiff uses the Citadel mark in a fair use and non-infringing manner to criticize and ridicule Citadel and its billionaire CEO. Paragraph 55. After the underlying UDRP decision was issued, but before the 10-day period to prevent transfer of the disputed domain had lapsed, defendants submitted a complaint to Twitter claiming that Brit's use of the account at Citadel Air violates defendants' trademark rights and Twitter's rules. Paragraph 56. Plaintiff's Citadel Air Twitter account is used for an obvious parody in furtherance of his free speech rights. Paragraph 57. Defendant's complaint to Twitter has caused a suspension of the Citadel Air account, with Twitter citing a violation of its rules, thus damaging plaintiff's reputation and prohibiting him from exercising his right to free speech. Paragraph 58. As a matter of law, plaintiff's use of Citadel Air to parody and criticize defendant and its CEO does not infringe or dilute any claimed trademark rights the defendant may claim in any Citadel trademark for its financial services and or any other product or service. Prayer for relief. Wherefore, plaintiff requests that the court enter judgment. A. Declaring that plaintiff's acquisition and use of the domain name citadelair.com is not unlawful under the ACPA 15 U.S.C. 1125D. Part B, or Paragraph B, declaring that plaintiff's acquisition and use of the domain name citadelair.com does not constitute a registration with the bad faith intent to profit from any mark alleged to be owned by defendant under the ACPA 15 U.S.C. 1125D. Paragraph C, declaring that plaintiff is not required to transfer the domain name citadelair.com to defendant. And paragraph D, declaring that the registrar, GoDaddy.com, LLC, shall not transfer the registration for the domain name citadelair.com to defendant. Paragraph E, declaring that plaintiff's use of Citadel Air to criticize and parody Citadel and its CEO does not infringe or dilute any trademark rights claimed by defendant in the name and mark Citadel. Paragraph F, declaring that Twitter must remove plaintiff's at Citadel Air Twitter account from suspension or any termination. Paragraph G, for such other and further relief as the court shall deem appropriate. Dated December 8th, 2021.